Well, for more on this, I'm joined now by the Labor Senator and Shadow Home Affairs Minister Kristina Keneally. Thanks very much for joining me this afternoon.
My pleasure, David.
Let's start with John Setka. As we saw there, he and his wife say that he's the victim. He never attacked Rosie Batty, he says. Do you still think he should be expelled from the Labor Party?
Mr Setka has, in fact, acknowledged that he has made comments about Rosie Batty. Anthony Albanese has come to a determination that those comments are not reflective, in fact, undermine Labor Party policy when it comes to combating domestic violence, indeed are out of step with mainstream Australia and our national efforts to keep women safe from family and domestic violence.
If he made these comments, right? So how can Anthony Albanese or you be so sure that he did? Because he's saying that's a lie.
Well, Mr Albanese, in making his determination, undertook inquiries, came to satisfaction that this is what Mr Setka said.
He didn't talk to John Setka,
I trust Anthony's judgment here. He consulted with the leadership group, came to a determination that this was appropriate action to stand up on behalf of the Australian Labor Party.
You and the leadership group. Has anyone in the leadership group spoken to anyone who was in that meeting last week?
I have not done so. I'm not aware of the extent of the inquiries that Anthony made, but I do trust his judgment.
Because that would be a pretty important step, wouldn't it, to talk to someone who was in the room?
And I understand that Anthony has made a series of inquiries and is satisfied that these are the comments that Mr Setka made. I have seen Sally McManus express concern about these comments.
But she wants to talk to John Setka.
Yes, and she has, and that is her role to do so as the head of the ACTU. What Anthony has done is made a determination that these comments about Rosie Batty, and I need to be clear, the determination is made about the comments relating to Rosie Batty, not about matters that are currently before the court that Mr Setka is also involved in. But these comments about domestic violence, about Rosie Batty, are not in keeping with the Australian Labor Party. Anthony has moved that the party expel Mr Setka, and the party will determine that at its next
Just finally on this, given he's contesting it, saying it's all a lie, should he at least be given some natural justice in that process?
Well, there is a process. There is a process. This now goes. Anthony has asked the party to take this up at its next meeting.
So how does that work? Can he make his case before the National Executive?
If he wishes to, he can. But Anthony has made a determination that the party should suspend him immediately and should move to expel him.
And if the CFMMEU sticks with him as its Victorian leader, how is that tenable for the party, for the union to be affiliated with the party?
Well, let me first say that I think Mr Setka should have a long, hard look at himself and ask himself if his position remains tenable. I don't believe that it does. He himself has said that he is under great strain and stress.
But he wants to stay.
I would suggest to him that it's in the best interest of his members, who need a union and union leadership that is focused on their rights and conditions, their safety at work, to be fully focused on that job.
But if the union back him in, does Labor want to be affiliated with that union?
Yeah, the union is bigger than one individual, Mr John Setka. The union is full of its members, full of men and women who rely on the union and the union movement more broadly to stand up for their rights, their safety at work.
Let's move to the issues of press freedom. Do you want an inquiry into press freedom?
What I would like is the Parliament as a whole to, with a set of fresh eyes, look at the question of our national security legislation and whether we are getting the balance right when it comes to media freedom. And that includes both reviewing the laws that have been passed, significantly the full raft of legislation that's been passed since 2013. There has been a significant amount of legislation passed since the coalition came to office, but also a number of the proposals that are coming forward from organisations like News Corp, like Seven West Media, like the Law Council and the Media, Entertainment and Arts Alliance. The raids of last week have put front and centre the very real question whether or not media freedom is continues to be a basic tenet of our democracy that we can rely on. I think it's incumbent upon us as a parliament to look at the question squarely and honestly and to deal with it thoroughly.
Through the Joint Standing Committee on Intelligence and Security, is that the best?
Well, I would suggest to the government they consider the options before them. They could task the PJCIS to do this, and let's be clear, they would need to task them to do it. The PJCIS, as it's currently constituted, can't just simply decide on its own to do something. But the government should have a think about constituting a separate parliamentary joint committee. It would bring in both houses. I don't think it's productive if we have multiple committees and multiple houses looking at the same issue, talking to the same group of stakeholders on what is a complex area of law and a complex area of leadership and culture as well within the government. So I would say a parliamentary joint committee that would allow participation from the parliament more widely would be something the government should consider.
Some of the media companies, including News Corp, are saying, you know, an inquiry we don't need. We know what needs fixing. Here are the laws that need changing, and here's how, you know, this is not new. They've been making these points for a while. Let's just go through a couple of them.
Can I say on that first, I understand the point that News Corp are making there. I saw Campbell Reed's comments this morning. What I would reflect is that this is going to end up in an inquiry in the Parliament one way or the other. Even if the government were to meet with News Corp and come up with a legislative agenda, it's still going to end up in some sort of parliamentary
Let's go to some of the concerns,
and that's appropriate too,
some of the concerns. One is around the metadata laws, that journalists' metadata can be accessed without them being told.
Yes, that is
that a concern for you?
That is an issue that was, in fact, canvassed during the metadata laws debate. Labor insisted in our amendments that that data could not be accessed without a warrant. Now, the media organizations...
It's still without telling the journalist.
Exactly, and so the media organizations have what I believe is a rightly raised the concern as to whether or not that should stand.
What do you think?
Well, I think it's something that needs to be considered because it is a fairly extraordinary set of power that the government now has to be able to access a journalist's metadata. That gives them a whole lot of information about who journalists are talking to, when they're talking to them. There's also a provision within that legislation that journalists cannot report the fact that a warrant has been accessed for their metadata. And again, you know, when we are talking about freedom of the press and the public's right to know and evaluate actions of their government, that at least needs to be contested. We need to now contest and look at whether or not that is a reasonable position.
So when a search warrant or a warrant to access metadata is being considered, should the journalist or the media company be able to contest that, to argue, hang on, this story is important in the public interest, we don't think there should be a raid?
Well, in fact, I would say that raises two questions. One, whether they should be able to contest it, and two, whether they are able to argue that it is in the public interest. And this is another issue that has come to the fore. We have inconsistent application of what constitutes public interest defence when it applies across the different sets of legislation that we have that cover national security. And that has led to the types of circumstances we've seen even with these raids, which were conducted under the Crimes Act of 1914. That has a different application of a public interest defence than, say, the laws that were passed last year under espionage and foreign interference.
But those laws last year, I mean, they even though there is a public interest defence for the media, journalists can still be landed with 5 years in jail just for receiving information.
They can. And
is that a problem?
I think it's one that the Parliament needs to look at, absolutely.
But these are all things Labor supported.
And, David, let me be clear, at every juncture, Labor has moved hundreds of amendments to this legislation.
You still back that, you back the metadata laws that we just talked about earlier, and now you're saying you do have concerns about these.
I think it is fair to say, in light of the raids that we have seen and the public debate that has erupted in Australia and around the world, debate that is now being led by people like Michael Miller from News Corp, Ida Buttrose from the ABC, whether there have been unintended consequences, whether parliaments have moved and erred too heavily on the side of national security, indeed, even whether media organisations in their reporting have had too heavy an eye towards the national security aspects and not raised themselves enough questions about the impact on reporting, on media freedom and on individual freedoms. You know, when something occurs, when new information comes to light, when we are caused to question the impact of the laws, it is an incumbent upon us as parliamentarians to have a fresh look at this legislation and seek to come to some answers to these questions. They are not going to go away, these questions.
Something more specific for Home Affairs, I suppose, stepping back from all of this, is too much low-level information being classified as national security secrets?
You know, there's something in political theory called the secrecy dilemma, right? My colleague Jenny McAllister gave a very good speech last year that spoke to this very question. And yes, there are things even in a democracy that governments need to do in secret in order to serve the public interest. In fact, it would undermine the public interest if some things were put out in public realm and not kept secret. And I accept that. I fundamentally accept that. But when you see things like the information that was leaked out during the Medevac legislation debate. Now, ASIO said that was a seriously damaging leak. And I have to take the Director General, Duncan Lewis, at his word on that. The government then seized upon the content of that information and then seemingly managed to declassify it just a few days later. And it really does, I think, raise a series of questions about what is being kept secret and what is being released for political purposes rather than for serving the public good. And if I can come back to this question about raids and secrecy and information, I think the other risk the government currently has is that there is a perception of bias, and particularly around what leaks of information get investigated and what do not.
Bias at the AFP?
Well, I don't think the AFP is biased. I think
they're the ones deciding how to investigate.
But I think the risk now sits, and the responsibility sits with the elected government. The risk now sits, if you're standing back from this and looking at this saying, OK, well, you have leaks that occurred a year ago or 2 years ago about the Afghan files or about the ASD proposal for the ASD to be able to look at Australian citizens. We heard nothing about those investigations for a year or two. Then suddenly, wham, there's raids on journalists' homes and media organisations with extraordinary warrants to alter or delete or remove information. When we have a leak those leaks embarrass the government. When you have a leak that benefits the government politically, as the one did in the Medevac...
What are you saying there? That's the AFP's call?
Well, the question, I think, is for the government to stand up and say what they knew about these investigations and for the AFP...
They've said they weren't alerted to that.
Well, Peter Dutton has not stood up before the nation's media and answered questions on what he knew about the raids in terms of...
Well, he said he received no prior information.
He said he received, but he hasn't done any media. He hasn't faced any tough questioning about this, and he has not answered the questions of what he or his office knew about the leak, the seriously damaging leak, as Duncan Lewis put it, of ASIO information.
Just finally, you mentioned the Medevac laws. The government will be seeking to repeal these Medevac laws when Parliament resumes. Will Labor seek to keep these laws in place?
Well, first of all, we don't have any legislation from the government. They haven't provided us with any.
We know they want to get rid of it.
I just want to put that out there. All we have are what they've said during the campaign. Labor supported the Medevac laws for two reasons. One, because it ensured that people who were on Manus and Nauru, if they needed medical care, had an avenue to be able to try to get the medical care that they needed. It is demonstrable that there were people who were not able to get the care they needed.
And have they now? Is there evidence that it's done the job of transferring people who otherwise would not have been?
Yeah, there is, but let me go to the second reason we supported it first, and that is because it allowed the minister to have final discretion as to who could come in the country in order really to ensure that national security and other concerns were the province of the minister. There is from evidence that there are people who've been able to successfully use the Medevac process in order to be able to gain medical care.
I'm told, though, the rate of transfer has slowed since the Medevac laws came in. Is that your understanding?
I have not had evidence to that effect put before me. What I do understand is that, in fact, more people have come to Australia to receive medical care outside the Medevac process than within it.
What does that say?
Well, what I would take from that is that there is a recognition, perhaps, by the department and by the government that people were uncomfortable. People in the Australian community were uncomfortable with the idea that people on Manus and Nauru were being denied medical care, particularly if it was in life-threatening or serious mental health conditions. The Australian community and the Australian Labor Party fully supports Operation Sovereign Borders, the things that we need to do to keep our borders secure. Boat turnbacks were safe to do so, regional resettlement and offshore processing. But we do not need to treat people cruelly or to deny them medical care. And I would say that what we've seen since the passage of Medevac is a recognition from the government and from the Department of Home Affairs that the Australian community wants to see sick people get health care.
Is there grounds for some compromise here?
Well, we haven't seen anything from the government and no suggestion as to what they're going to do with this bill.
Kristina Keneally, Shadow Home Affairs Minister, thanks very much for joining us this afternoon.
Thank you.
Appreciate it. Now, the Northern